that would basically determine whether or not Trump does have carte blanche to be able to fire all of these nonpartisan officials who really, again, make society function?
Brian, there is no doubt in my mind that in the coming weeks or months, the Supreme Court will accept review of a case that will revisit the powers of the president to fire people in a completely unlimited, unrestricted way, regardless of laws that have been passed by Congress to give government some continuity and protect at least some functions of government from hyper politicization or nefarious politicization or just plain nefariousness. So I think the Supreme Court, at least the right-wing bloc of the Supreme Court, has probably been champing at the bit to try to revisit the scope of presidential power and perhaps overrule the Humphreys executor case.
Well, Glenn, to that point, does the Supreme Court weighing in here at all, does that give any inkling, any indication of whether or not they might take this case, whether or not they want to delve into this area? Can you read anything from the tea leaves here?
Yeah, Brian, that's the perfect question. And here's why. Because with the Supreme Court saying, listen, this is a preliminary matter. This is a case that is in a very preliminary stage in the trial court, the federal district court, and there have to be more proceedings in order to really flesh out a factual record so that we can, if we want, take the case thereafter and revisit that factual record. So I would say on the one hand, if they had such an overwhelming appetite, they were starving to really expand presidential power, what the Supreme Court could have done is they could have said, look, procedural niceties aside, we understand that ordinarily these kind of preliminary rulings, a temporary restraining order that is set to expire on February 26th, ordinarily are not appealable, but dang it, we want to overturn Humphrey's executor case. We want to expand presidential power right now, and we don't like the fact that, we're bound by that and that the president's, powers are being unduly restricted in our supreme judgment. They could have taken it, and that would have been a really dangerous indicator, I think, for the rule of law and for the health of American democracy. So we can read something from them not immediately going there and saying, no, we're going to follow the normal course, and when and if we decide the case, which has been resolved in the trial court and gone through the Federal Circuit Court of Appeals in D.C., is ripe for us to review it, that is when we will review it in the normal course of business.